Welcome all to today's class on Colombia vs. Peru Asylum Case. This is Dr. K. Sangeeta for Public International Law. Introduction. The first half we will see the case of Colombia vs. Peru, commonly known as the Asylum Case, which is a landmark case under public international law. For several reasons, inter alia, its expansion of law on extradition and political asylum, development of customary international law, and the concept of sovereignty in international law was understood. The case having been decided as early as 1950s, judgment on 20th November 1950, has played a significant role in molding the international law and giving it a shape and its stance even today. When you see the factual background of asylum case, Peru is a country in a continent of Latin America or South America and has its capital at Lima. In 1948, the country went through rough times where very long tussle broke out in Lima for the acquisition of political power and the government. After long struggle and siege, the military junta government came to power, defeating the American Citizen Revolutionary Alliance, which automatically became the opposition party. As a result of this loss of power in the government, the leader of the opposition party, Victor Roll, commenced a rebellion against the junta government in Peru, intending to dethrone them. However, due to extreme political powers vested in the government, the rebellion was summoned within 24 hours. 3 months after this escape, on January 4, 1949, the Peruvian government was informed about his asylum and they immediately claimed his custody. On the other hand, the Colombian embassy claimed that Victor Roll has a right to passage and requested safe passage for him to leave the country. Moreover, the Colombian government unilaterally qualified the offence committed by Victor Roll to be a political offence and allowed political refuge without consideration from the Peruvian government. The already engaged government of the Peru categorically denied the safe passage, arguing that there exists no right of political or diplomatic asylum for Roll, since he is responsible for the rebellion or in legacy, which is a common crime. Due to non-agreement between both the states, Peru and Colombia, the situation reached a diplomatic stalemate. No provision was left for either party rather than to move to diplomatic stalemate, and no provision could either help them to move an independent authority. An agreement was signed between the two states and it was decided that the ICJ will adjudge the matter and award will be agreed to by both the parties. Issues before ICJ: whether the state of Colombia had the right to unilaterally qualify the offence of Victor Roll as a political offence under any international treaty or customary international law or under any general principles of international law. Second, whether the Peruvian government was bound to grant safe passage to Roll to leave the country under international law. Whether the Colombian government and the ambassador was liable for violating the provision of Havana Convention on Asylum 1928 by providing and continuing to provide asylum to the offender. Relevant legal provisions. Article 18 of the Bolivarian Agreement on Extradition 1911, Article 1 and 2 of the Havana Convention on Asylum 1928, Montevideo Convention on Political Asylum 1933, and the customary international law are all applicable. Arguments on behalf of Colombian government. The Colombian government put forth the threefold argument before the court to substantiate its act. Now, before proceeding with the argument, it is vital to note that the present case, Colombia has filed a claim before the court to hold its asylum valid and allow safe passage to Victor Roll to leave the state. On the contrary, Peru has filed counterclaim to hold the asylum invalid and extradite the offender to the Peruvian government and deny safe passage to the offender. Hence, both the parties try to justify their actions through the profound argument. The threefold argument of the Colombian government can be explained as followed. First, Article 18 of the Bolivian Agreement 1911. Every country is entitled to grant political asylum to any of the political refugee in accordance with the international law. Second point, it has been further reiterated under the Montevideo Convention 1933 as well. Both the agreements were ratified and signed by Peru and Colombia. These provisions were relied upon by Colombia and argued that according to these treaties' obligation, Colombia had every right to grant asylum to the political offender and hence no law has been violated. Further, Colombia argued the existence of an ancient and long practiced custom in South American countries that vest right upon these countries to grant asylum to anyone seeking it. Further, Colombia also claimed that the custom does not prevent any unilateral qualification of an offender as a political offender for the purpose of granting asylum. Colombia prayed that since the state has the right to qualify anyone as political offender unilaterally, it is the duty of the other state to respect such qualification and allow safe passage to such refugee or the asylum seeker. Lastly, Colombia argued that according to Article 2.2 of the Havana Convention, Peru was obliged to provide free and safe passage to asylum seekers to leave the country without any harm. Moreover, it is implored that the provision of this convention aligned with the American custom demands respect for such rights and hence Peru is liable to provide passage to all. Lastly, arguments on behalf of the Peruvian government. The Peruvian government filed a counterclaim to claim the extradition of Gaul and holds Colombia liable for hiding an offender. The arguments of the Peruvian government were twofold. First, the Bolivian agreement is a treaty on extradition and does not deal with asylum. Further, according to the Havana Convention on Asylum, political asylum can be provided only in favor of a political offender. Thank you.